Well, I've got a special guest today. This is quite a treat for you all because Chris Paterson, I knew years and years ago. And since then, he's escalated to enormous heights in the legal fraternity. Chris has led some of the biggest decisions in my employment world, but he went far, far beyond that. So welcome, Chris, and thanks for coming. This is a bit of a treat for us.
Oh, Max, I'm very flattered and humbled. It is, it's a treat for me as well. It's always good catching up with you. I really enjoy our discussions.
Well, look, Chris, you're actually now into broader parts of law. You're doing some pretty high-level decisions, or you're involved with these decisions and leading them and advocating them. You really have grown a long time since the last, well, it must be 25 years since we've talked.
Yeah, although 25 years is quite some time. Like most legal careers, unfortunately, it does take time to put in the yards and the effort, and to also grow. I mean, it's really important that lawyers do that rather than sort of get too fixed in a niche. So yeah, it takes time. But I'm very happy with where my career's at. I've got a lane that I'm very happy to be in, and I'm very grateful that I've got the career that I have.
Well, we better put Max into context here because actually I'm not a lawyer and I never have been, but I have great admiration for lawyers. And while I have a pretty in-depth understanding of employment law, it goes far beyond me, where people like yourself, barristers, whatever, have a more depth. So, but what I have gained over the 30-odd years of dabbling in employment law, and probably 25 years seriously, is a bit of a grasp and understanding how law works. But one of the big issues that I'm confronting today in the employment fraternity, which you only touch on occasionally now, don't you?
Yeah, so employment law would be approximately 15 to 20% of my practice now. I mean, once upon a time it was a much larger percentage, probably up to 80%. But it's still an important point. I haven't wanted to let go of employment law. I still get a lot of satisfaction out of assisting clients.
So what other law do you touch on? Commerce, tribal issues, with the Waitangi Tribunal? Do you do some of that work?
Look, I've never appeared in the Waitangi Tribunal, although yesterday I did receive a delivery of quite a tomb of a book. It's the latest book that's come out on the Treaty of Waitangi. It's how the English interpreted the English version of the treaty. All 750 pages of it. I sat down last night and got through the foreword by one of our Supreme Court judges. And I am looking at that, but that's purely coincidental. I've never practiced in the area.
But what are the other areas that do you practice in?
Well,
everything.
I'm a generalist. So, Max, the easiest way of describing what I do, and this is how I describe matters to people, is to say, look, my specialist area is dispute resolution. Okay, so people come to me to help them when they're in a dispute or wanting to avoid a dispute, to seek out ways that can be efficiently resolved. The areas of the law that I try to stay, in fact, I expressly do decline, mainly because there are other people out there who can do a far better job than me, is the areas of child custody and domestic violence.
Oh, yes, I would stick away from that as well.
Look, they're just two areas that are quite close to my heart, and I just know that I couldn't do the work at the level that I think needs to be done.
Although you do touch on some marital issues. You and I, we crossed on one time where we just touched on it. We weren't across the table from each other, but certainly we did touch on that. So you do touch on some of the marital issues, don't you?
Yeah, look, relationship property has actually been quite a growing area for me in probably the last 10 years. And I enjoy it. In fact, just before we caught up today, probably the last file that I worked on for today, kind of officially finished work for today, was a relationship property matter. Although in saying that, I think I've got another one tonight that I need to give some attention to.
By the way, folks, this guy doesn't give up. He works night and day. I know you do. You do. You put some enormous hours in.
Well, look, once upon a time, Max, I think I'm a self-diagnosed workaholic, but that was quite a long time ago. I am a very firm believer in the work-non-work balance. I think it's incredibly important, particularly for professionals like you and I that are involved in contentious matters.
All right, let's test that. What are you doing Monday?
I am taking Monday off, and I'm hoping that I can persuade my lovely partner Kath to come up to Te Aroha. I'm very fortunate and blessed. I've got a beautiful property up at Te Arai. Do you know where that is?
No.
Okay, Te Arai is probably one of Auckland's best kept secrets. God, that's a cliche to say that.
Yeah, but it's true in a lot of cases.
Yeah, so it's right on the northeastern border of Auckland and Northland. So it's just south of Mangawhai and just north of Parkery. Now, Te Arai has become world famous. Okay, if you're a golfer or golfing people will have heard of Te Arai. That is because an American billionaire from California, Rick Kane.
Yes.
Yeah, he's him with a New Zealand developer called John Darby have built. From what I understand, it's ranked the second top golf course on the planet outside of the US.
Wow.
Okay.
Wow.
Now, I've never played there, mainly because I'm hopeless at golf. I almost hate it with a vengeance, mainly because I am hopeless at it. If I take on a sport and I don't kind of pick it up, I tend to steer away from it. Maybe it's my competitive nature. I have been very privileged to have lunch there. I had lunch with Nat Cheshire, who him and his father Pip were involved in the designing of the clubhouse. And they've also been involved in the design of a number of the very flash, I'll use the word flash, homes that have been constructed around the golf course.
Okay, let's get back to it.
Yeah.
So your legal fraternity, I've tested you on your legitimacy in terms of having time off because I didn't believe you because you just really cramped that work out. The other thing is, the big thing I wanted to talk to you about is what I'm discovering in employment law is the average Joe Blow, the average person in the street really cannot afford justice. It's getting to that point. If they've got a case to take, they need help. And the law has become that complicated, that difficult to manoeuvre around. They need help. And if they don't, muggins them. Because people who understand the law, like yourself and me, could run rings around them and they'd have no idea. And the judiciary don't always let us get away with that, but they quite often will, just to get the case finished and on with the next one. I also find mediators love that situation because their objective is to get a settlement. The best way to do that is go to the pocket of the worker or the average person and say, where is it going? Now, I guarantee you're not cheap. I'm not cheap. Where is the law going to end up?
Okay, so look, Max, you and I never actually spoke, just for the people that are listening, about what the topics were going to be. But I'm delighted that you've raised this because this is an area that I'm very passionate about, and that is access to justice. We do have an access to justice crisis in New Zealand, and we've had one for quite some time. It is growing. It is growing, and in saying that, it's not that no one's doing anything about it. There is some fantastic work being done by many parts of the legal profession, but also the wider community, to enable people to be able to get to access our system of justice. But more needs to be done. Now,
but Chris, to put in context, I understand it's not just a New Zealand phenomenon, because I believe Lord Cook many years ago, 10 years ago, said it was that way in the UK right now. I can't think of the name. What do they call it now? The domestic laws, or it's the same as our district court laws, but they are almost out of the reach of the common man.
Oh, look, absolutely. Another law lord, Lord Bingham, has written extensively on this topic. Closer to home, the Australian High Court, which is the highest court, Justice Grisham and others, have also said that this is a worrying development that actually threatens the rule of law itself. If citizens can't access our courts in a way that that they can afford or is accessible to them, then it is a significant.
And you concur. You agree
Absolutely,
that it's getting to that stage, is it?
Yes. Yeah. No. Look, it's
access to legal advice is available, but it comes at a cost, and that's what the issue is, isn't it?
Yeah. Well, look. I mean, there's multiple facets to it. Okay. At a basic level, if you think about how a civilized society operates, there are. I'm starting at the top here. If you divide our legal system into two parts, one part being criminal and one part being civil, both of them have a commonality, and that is that something has happened or not happened that should have or shouldn't have, and there needs to be something done about it. Now, if I take criminal law. there is a crime that's been alleged to have been committed. Okay, now that there is a process that's followed, and we're fortunate that in New Zealand we actually do have a piece of legislation called the Criminal Procedures Act that actually does outline the process that should be followed, and it's a codification of a process that's developed over many decades. That process needs to be followed, but there are some costs and barriers in making sure the process is accessible to all. In our civil system, you'll have a dispute where you've got one person will say, my rights have been infringed, and another person may say, well, I don't accept that, or if I do, what you claim, the cost of that is different. And again, that process needs to be followed through for a resolution. And generally speaking, if I take the civil area, and I'm happy to come back to the criminal, there are only 3 ways that any dispute at its most basic level is resolved. And the same applies for employment law. And that is either the plaintiff or the claimant either packs up their tent and just gets on with their life when they weigh it all up.
And does that happen often?
Well, in terms of does it happen often, it happens, okay? And sometimes it's the right decision, okay? But sometimes it's not. And sometimes it's because the plaintiff or the claimant realises that they don't have the resources to be able to. And let's put that in
plain English. Yeah. It's the affordability, isn't it? And that's where it comes down to it. It's out of the reach of the common man in terms of their level of remuneration, the amount of money they've got, and can they afford legal help?
Correct, yeah. And now look, the other 2 ways that civil disputes and employment disputes fit into that category are resolved is either by agreement, and Max, you've got a lot of experience in that area, or it's by a judgment or a determination being handed to the parties to the dispute by a third party, a neutral third party. In the employment context, that'll often be, for example, an employment relations authority member or an employment court judge. Outside of that area, it could be a court judge or an arbitrator or an expert that's been appointed by the parties.
So, Chris, what is one of the primary reasons for it? Because I know there's a myriad of reasons, and you talked about all different facets. But the primary reason I've identified, and I think you concur, is the affordability of it. But what causes that unaffordability? Is it because lawyers and advocates charge enormous rates, or is it the complexity of law itself? Is it too complex?
Yeah, okay. Well, Max, that's a multifaceted issue to address, but I'll start with some of the key aspects to answering that. We have a civil system which is based on the adversarial model, okay? And whilst in the Employment Relations Authority, it's more of the European continental base, which is more of an inquisitorial model. You can go beyond the Employment Relations Authority into the court, which then clicks back into this adversarial model. When I talk about the adversarial model, how that operates is that the parties will present their respective cases to the judge, okay, who is not there to advocate on behalf of either party, and will determine the dispute by reaching findings of fact and applying them to the law, and using a very basic formula, hey presto, here comes a decision. Now this then leads into a very important point, and that is that judges in our court system have an interest in, and I'll say sometimes to the detriment of the parties, the actual stakeholders to the system, of reaching what they call an accurate decision. So it's called judgment accuracy. And how they do that is they do that by primarily, or the main way they do that is through rules, court rules. And the rules are found for our High Court and the High Court rules and the District Court, which have very similar, they're almost word for word identical. And even the Employment Court has its own form of rules that it tends to follow. But where there are gaps in the Employment Court's regulations or rules, I'll fill that in with the High Court.
Well, let me explain what happens here, because I'm with Chris a million miles on this one. Because in the employment world, the text within the legislation to test if a person's been unjustifiably dismissed is what would a fair and reasonable employer do in the circumstances. Now you go, what the hell? How does that guide an employer into terms of when can I dismiss somebody? Well, it's exactly what Chris is saying here. The courts have set a whole regime of rules and points of interest, and I think these on that matter alone, that one paragraph, there could be a novel written on it. Well, there would be. There is novels written on it.
Oh, there are. I mean, it's
textbooks just full of all these rules that just come on and on and on. Yeah. And what it seems to be unfair is that everybody seems to have to know about that. Otherwise, they're naive and justice can avoid them.
Yeah, well, ignorance of the law is no defence, but in saying that, the law has to be reasonably capable of being found by the average person.
Does it?
Well, it does. Well, I mean, if you think this is a key point. So, I mentioned Lord Bingham before, and the reason why I did is because I've been thinking about the issue of the rule of law, and he wrote a book many years ago on the rule of law, and one of the points that he makes in that is that as an essential requirement of the rule of law is that people have to be able to find it. And he refers to in his book to a situation which had to do with I think it was a rating review for a property, and it had gone through the first instance court and then taken on appeal. And so there were two lawyers involved presenting their respective clients' cases, and there were three judges. And then after the Court of Appeal had released its decision, somehow it came to someone's attention that there had been a regulation passed many years ago which actually made their decision wrong. Okay, and what the upshot or the short point of it was you have three very smart judges and two very smart lawyers. They couldn't even find the law. So how do you expect the average person on the street to find it? And this is a failing. Now, one thing New Zealand is very good at is producing laws. So we crank out.
Every day, Parliament sits and makes another one.
Legislation and regulations like it's going out of fashion. So it is difficult. But the age of the computer and the internet has created advantages but also disadvantages in this area. Look, anyone who has got, and I'm not, without talking about the digital divide, because we do have this in this country, some people do not have computers or access to the internet, and that's an area that I'm really worried about. And just before I move off that, the courts are currently have produced a draft consultation document on a digital strategy for the courts. It's a great strategy. I've read it and I've thought this is fantastic. But I've written to the ministry with some suggestions on how to make it a bit better. And
is it free? Because a lot of these things, like what have we used to Western law and all these things.
Those research on
they cost money. They cost huge money. They
do. But look, one area that is free is that our legislation, our regulations are free. If you've got access to the internet, legislation.govt.nz, you can find it, okay?
So in the employment world, you'll find that piece of law I quoted before.
Absolutely. And I can kind of drill down to
but
that.
But you won't be able to find all the judgments that the judges have made around it.
Well, kind of yes and no. The employment court and authority determinations and judgments, as well as the district and high court, there are some of them available free on the internet, or when I say free, without having to have a subscription. Okay, but it's not particularly great. But there is a resource which is run out of Otago University, I think that's where it is, which is part of a resource worldwide, and I always get the acronym wrong. But it's and look, perhaps I can send you, because I don't know if you do podcast notes afterwards. But it's
but I could tack it on the bottom of this.
Okay, well, let's tack it on the bottom, because I don't want listeners to get this wrong. But it is a free database.
Oh, and I think I've heard of it. I'm lost for the name as well.
Yeah,
but I have heard of it. But I think when I tried to get on it, I had some difficulties. But
I'm going to give you the details, because I use it. I mean, I pay for some what I find some more on point databases. But it is a great database for someone.
It'd be so nice to have a Wikipedia.
It is.
It is like that.
It is like that, and it's free. And look, it's actually they're under resourced. I have made some donations to them over the years. It reminds me I probably should make another donation because they rely on funding by way of sponsorship and donations. I don't think they get any funding at all from the taxpayer. But it's a great public resource because the database is full of case law.
All right, so look, just moving us on because that means that we've got there is a resource in New Zealand which I don't even know about, which I think I do, but I'll have to check it out, and we'll provide that for you. But is the laws too complex in New Zealand, or is there an easier way of going about this, Chris? I know this is really difficult because the best brains in the world are looking at this.
Okay,
how do we make laws more? Easier for the common man to understand and also to apply. Yeah,
okay. Well, I mean, there's multiple ways that can happen. One of them is in our legislation, and the key to it is having clear drafting, so that the intent of Parliament is as clear as possible. And hopefully
it is a challenge,
and hopefully avoids people arguing over what words actually mean. I mean, that can help. Look, another area is actually education. I mean, I've been privileged that I've had a very comprehensive and ridiculously expensive legal education, part of which was paid for by the New Zealand taxpayer. So I did my undergraduate at Otago. Later in life, I did a Masters of Law at Melbourne University, which... in my graduating year, which is 2019, Melbourne was ranked the 9th highest ranking law school in the world.
Monash,
no, Melbourne University, not Monash, and ranked only just behind Stanford. Now, I've been super privileged in that regard, but it has occurred to me that there is no reason why we couldn't teach basic laws at high school level. As part of, I guess, citizenship education.
Well, I've got to say that in employment law, it's incredible. The young ones coming through now from school leavers are leaving their employers for dead because they understand the fundamentals of employment law better than employers. So your point is coming up to a certain level, but what you're advocating is even probably higher than it is.
Yeah, and also accessible information made available. Like, look, we can all do more. I mean, there are projects that I work on to try and make the law accessible to people at no cost. Okay, and like being here today is part of that commitment, because I'm hoping that someone will listen to this and they'll come away knowing a little bit more about the law than they did before they did, and at no cost other than their time, maybe when they're going for a walk or driving their car. But one area, if we focus back around to employment law, is that MB, the Ministry of Business, Innovation and Employment, they could do more about making information available to people about our employment law. And I mean, one area that you mentioned is that concept of a justified dismissal. Okay, and whilst it's in our legislation that someone can have a personal grievance if they've been unjustifiably dismissed, as you know, justification isn't
and that's what
addressed.
I was talking about before. No,
well, not in a way that demystifies it. And the case law talks about what the fair and
reasonable... But the law journals do a fairly good job at that, if you can afford the accessibility to them. Yeah,
and of course, there is some, I guess, publicly accessible at no cost access to some of this information. But
MIMBI do access to the Employment Relations Authority, which is a low-level judiciary in my world. And, of course, the Employment Court, you can, I believe, you can Google that and get access to the decision. Yeah. But you've got to read a 40-page or 50-page decision. And do you understand it? Probably not. Not to the man in the street.
Yeah, well, look, good point, Max. I thoroughly agree with you. There isn't anything in my mind that would prevent the codification of justification. Okay, so you could codify what will amount to justification, and you could put that in the legislation. Now,
that's significant what you've just said then. Let's unravel that, because I actually think that could be a solution, because that could really do it. Now, it means legislation would have to be hell of a lot longer than it is, but it's going to have that reference there, easy for somebody to go through and saying, what would justify me to dismiss an employee?
Sure. Yeah. Well, look, it wouldn't be perfect. There would always be examples of where, if it was codified, an employer could say, well, I've ticked all these boxes, okay? And it's possible that an unfair result could come out of it.
And no disrespect to your fraternity, but it's also fodder for a up-and-coming lawyer who wants to make new ground and get somewhere in their career and challenging that code and saying, however, it could mean this as well.
Yeah, look, and that is possible, but the issue with once something's codified, and if it's codified in clear
legislation,
terms,
yes, it's
in clear terms, not only does it make it more accessible to where the goal line is. I mean, I use a rugby analogy since we've got a big test coming up on Saturday. It's only fair that you know where the try line is. Okay,
that's very clearly put.
That it's marked out. Otherwise, it can create unfairness. I mean, I guess what I'm suggesting is, and I'm not saying that this is a silver bullet, because it is conceivable that there will be instances where an employer could follow, effectively the checklist, and it would still result in some unfairness. But in saying that, you could contrast it to going, well, actually, employment relations authority members still get that wrong, and the proof of that is that some cases that are challenged to the employment court are overturned, and that is evidence that the authority member got it wrong. So there is no perfect system, but there needs to be a system that's at least accessible in the ways that I've talked about. And
you're quite right. You're saying, because that's again going back to my understanding of the world, but to take a case from the employment authority probably would cost on the average $15,000 to $20,000 for somebody, and those statistics are available. So, the Employers and Manufacturers Association published them. But to take it to the court, you couldn't go in there with less than another $20,000, and it does take enormous. Let me tell you a story of a guy. I've just met him recently. He lives on the shore here, and there's a housing development going next to him. He puts in a protest on it, saying, "I think this. You should look at this and this and this adjustment." It came back to them from the commissioners who were reviewing it at the time and said, "No, we're proceeding with it."
Yep.
So he went back to appeal it, and usually goes to the Environment Court, and the council said, "Tough luck, we've already accepted it." So he had to go to the High Court. He went to the High Court and said, "My decision wasn't fair," and the High Court said to him, "Tough luck.
Yep.
I've made a decision, you've got to stick with it." So he went to the Court of Appeal, and the Court of Appeal said, "No, you've got a case here. You should have been heard," and they didn't provide a good enough answer. Back to you, Mr. Judge in the High Court, and I want you to review it. He went and challenged that decision to the Supreme Court and said, "But I also want to win that decision." And the Supreme Court said, "Go away from us, go and sort it out with the Court of Appeal and the High Court judge." The High Court judge came back to him and said, "Look, there is an amendment. They've given a few extra sentences here, and I think you've got fair enough justification, but no, you're not acceptable." And so he was going to contest that again to appeal it, and his lawyer got discovery. Now, discovery, folks, for those who don't know, is all the documents. Chris will know exactly
from the other side, yeah.
Yep.
They
so he got all the documentation,
Yep.
and found that the lawyer, rather than talking to 5 commissioners out of the 5, he only talked to 2 of them and came up with that conclusion.
Yeah.
And so he contested that with the judge, and the judge said, "My wrong.
Yep.
I'll reverse my decision. You get everything you want. I'm pulling out of this. I'm out of here."
Yeah,
do you know what that cost him? $1 million.
Yeah. Yeah, well...
who can afford that?
Well, very few people can. That's the reality of it. Although we do live in a funny age.
But $1 million to prove your point on a housing development? Oh,
yeah, well, look, again, going back to what I was saying before, people who are involved in disputes want a resolution, and in some ways, an agreed resolution is the idea, is more preferable than one that's handed to them down the track for the reasons of avoiding delay and cost. I mean, justice delayed is justice denied. So yeah, look. I mean, if I went back to the employment area, there was the Radio New Zealand and the Snowden matter. I mean, that went on literally for years, and I understand. And I'm not an expert on this.
I almost lost my way on that. It did go for years and years and years.
But I think Radio New Zealand, which is funded by the New Zealand taxpayer, spent something, I don't know, in the realms of $2 million on that one, somewhere between 1 and 2. So these are eye-watering numbers. But look, everything has to be put into a context, okay? And the reason why I say a context is that some disputes, there's that much money at stake that $1 million is actually cheap. But in the employment area, that's very rare.
Every mediation I go to, the mediator will get to the point now to the employee and go, the next stage, Max, can you just tell your client how much it will cost him to take it to the employment authority? It might cost blah, 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 blah. And then the mediator will say, well, wouldn't it be better to settle it here and maybe take the $500 they've offered you and leave it for today because you've saved yourself Max's fee to take it to the next part.
Yep. Well, look, this is where practicalities come into it, and that is there are as Max
it doesn't make it justice. Though,
well, yeah, but look, at the end of the day, and I mean, geez, I might get stoned in the street for saying this.
Doubt it.
But life isn't fair, and those that go to court looking for justice are probably kidding themselves. I mean, it is called the Ministry of Justice, but often it's more the Ministry of Decisions, okay? Because people's concept of justice can vary as to what that is. It provides, my view is that an efficient court system, the greatest gift that it gives a civilised society is an ability to be able to put a dispute behind them and move on. Okay, whether it's the right decision or not, sometimes is not actually the main driver. And look, sometimes both parties hate the decision and are unhappy with it. So, you hear people talking about winners and losers. I'm going to win this case and you're going to lose. Well, sometimes both parties lose. And
I'm acting for a very prominent New Zealander that we all know, and I won't name her, but she worked for an organisation for 6 months and never got paid.
Yeah,
she got $10,000 out of the $100,000 contract.
All right,
she's got a very clear case, in my view, and we're taking it along the way. And now she's got to the point: one, she doesn't want the publicity because she's well known, and two, the cost is escalating, and the other side are pushing back and pushing back and pushing back, and I can't believe why, because it's so ABC. I've even asked for a decision on paper, and the authority go, no, I think we need to see you, so we're all going to have to front up. So now she's considering pulling out, and she'll get nothing for six months' work. No, actually, it's 9 months' work she did, yeah.
Well, I mean, that's probably a good example of your point that sometimes there's no justice. Look, each person has their own situation, and they've got to factor at the end of the day what is the best decision for them in the circumstances.
And I've been on the other side, exactly what you're talking about, Chris. And you, I'm sure you have, when you've got this stupid case, and it should never be run, and some person just is pushing it and pushing it and pushing it where it should never go anywhere.
Yeah, well, again, our system gives people rights to, if we go into back to the employment matter, employees, for example, always have the right to challenge a decision of an employer.
And then appeal it. And then to take it to the next level and the next level.
Well,
and that's cost and more cost.
Yeah, but also the flip side of the coin is that the rights aren't just a one-way street. Employers also have rights to take an employee to the authority and then to the court, and if they can get leave of the Court of Appeal, then there. And the exercise of those rights, in my experience, generally will be for good reasons, but sometimes the exercise of those rights are for inappropriate reasons, which lawyers would call an abusive process. But it's all very well to claim abusive process. Proving it is often difficult.
True, very true.
Yeah.
This has been an interesting discussion. Emma, I think we can go on further. There's a lot more.
Oh, look, I think there's several podcasts in all of this, and particularly around this area of access to justice. I think it's an area which, as I say, I'm very passionate about, and I'm very concerned. And
so am I. And I'm wondering if we got to go back to the fundamentals, and I'd like to talk to you about that one day. I mean, that's rethinking the law completely. Is, in fact, the legal fraternity the right thing to do? Is, in fact, should we allow our policeman or an appointed person be able to make decisions on the spot? Scary stuff. But, is that where we're going to end up going? Because this is escalating. You and I are both concerned. I can hear you too, Chris.
Yeah, absolutely.
This is escalating to a point where it's just outside the realms of just a normal person.
For certain segments of our community and our society.
See, that's the point I don't know, and you will know. Is it just employment law? I'm seeing it's really bad.
Oh, no. Look, it's across the board in all aspects of law. I mean, we do have a legal aid system. Now, that legal aid system isn't great. Okay, that's the politest way I can put it. They have increased the threshold for eligibility, but there is this what I call the majority, which are those that earn more than the legal aid threshold amount, but not enough to be able to to actually meet the costs of engaging a lawyer properly. And the shame of it is that when people say to me, "God, it's expensive to use a lawyer," a professional, I say, "Well, it's even more expensive not to if you get it wrong."
That's true. There's true in many cases.
So it's a matter of going, how do we design a legal system that captures a bigger pool or services a bigger pool of our community than the one that it does at the moment.
Now, I'm going to leave that there because that's your question for next time we go.
All right, maybe. Fantastic.
You're going to have some good answers.
I've thought about it a lot. I think I've got some ideas.
Oh, this will be interesting.
Yeah, great.
Because, Chris, you are a thinker and you're a practiced and you're actually legitimate. You're on the coalface of law. I think you're the right person to answer that question. So
thank you.
Wait for the interrogation next time.
All right. Thanks for having me on. This has been great spending this time with you today.
Yeah, I've enjoyed it too.